Good morning, everybody, and a very warm welcome to you to the Family Law Roundup for the short month of February 2026. It's lovely to see all of you in this morning on what is turning out to be a cloudy day in Johannesburg and hopefully lovely weather wherever you are in and around South Africa. My name is Mervyn Vermeulen. I'm an attorney, and I'm going to be talking to you about some of the notable, interesting, and relevant, shall we say, case law which came out in February of 2026. Assisting me today is Shantae Mouton, who will be moderating the chat bar for us and conversing and engaging with all of you lovely people as we go through the Family Law Roundup. As always, some rules, some caveats, some pointers. Please note, AI note takers are not permitted in this meeting. Please respect our intellectual property and the time it takes to prepare this session. As you will see a bit later, you are able to purchase the summaries which we have prepared and which we present free of charge by going to thinklegal.co.za. In terms of the case law, which we will be considering today, we are looking through 15 cases. As I mentioned, February was quite a short month, so we have 15 judgments that we will consider as we go through the roundup today. As always, this is not case law for lazies. We give you the introduction, we tell you what the case is about, and what you do with that information then becomes up to you. I have slides up. The slides are not really all that much to look at. If you can't see the slides, no problem. You will still be able to follow along with the information that I present to you verbally. The only prejudice you will suffer is having a big window of my face on your screen, regrettably. Now, let's go into the formalities before we get started with the roundup proper. What is ThinkLegal? As you know, we do open source webinars, paid webinars, and so forth. In short, ThinkLegal is a platform for the open exchange of trusted legal knowledge, and not trusted legal spelling by usage of the word form rather than for, and that is obviously my bad, and apologies for that, everybody. I will fix it in next month's slides. So it is a platform for the open exchange of trusted legal knowledge. We aim to connect professionals through dynamic dialogue, practical insight, and meaningful engagements across our platforms, trainings, and events. For more information and for resources, please go to thinklegal.co.za. You can register for our events, some of which I will tell you about shortly. You can join our WhatsApp groups, the Family Law WhatsApp group, the Commercial Litigation and Labor Law WhatsApp group, and then finally the Events Notifications WhatsApp group, all of which are moderated by our team to make sure that you get as much as possible of the knowledge and as little as possible of the spam, which is out there these days and is unavoidable, unfortunately. So please go to thinklegal.co.za if you do want to join our WhatsApp groups and join the conversation. From there, you can also join the Mediators Support Circle group, which is a place for mediators to debrief, share insights, and sanity check one another. So please also check that out. You can purchase resources, and that we will look at on the next slide, the optional course pack for today's session. And then finally, you can view past webinars by linking through to our official YouTube channel, where we have some of our past open source webinars free for consumption and dissemination as you see fit. So let's move on. As I mentioned on the previous slide, you can purchase some resources on thinklegal.co.za. One of those resources is the optional course pack, which we have prepared. The course pack this month consists of a bundle of approximately 264 pages of case law and a very nifty index page where we give you a little bit of the subject matter of the judgment, and that is obviously just as a tool to ease you into not having to go and trawl for the judgment online. You also get our summaries, which look something like so, where we tell you the citation, the court, an overview of the case, what was covered in the case, the outcome, and one or two notable quotes. It is a nice fast track into reading the judgment yourself, just to give you the main headlines of what happens so that you do not jump in without testing the waters first. We're almost through the plugs. We'll get started in about 3 minutes' time. But before that, I want to tell you about Divorce 101, which is one of our long-standing CPD trainings. We've just renewed our SOM CPD accreditation for 5 CPD points if you attend the 2 nights. It's a 5-hour training happening on the 18th and the 19th of March 2026. In other words, next week, Wednesday and Thursday. The cost is $1,100 per person for normal attendance. That will get you the course pack, attendance in the session, as well as a CPD certificate, which will bear the SAM, South African Association of Mediators branding, for 5 CPD points. Now, because we know that this is a topic which is quite vexing to practitioners getting into it, we are running a concessionary rate for candidate attorneys to attend for 700 Rand. To register for this, please email info@vermeulenlaw.co.za. Indicate that you want to register and that you are a candidate attorney. We will request you to provide us with proof of registration of your articles, your registration certificate from the LPC, in other words, and we will then issue we will put you on the registration list for the training next week. So you get a 400 Rand discount if you are a candidate attorney. Please note, for that registration, you do not get a CPD certificate. CPD certificates are only for the normal attendance registrations. Now, what we will cover in Divorce 101 ranges all the way from substantive to procedural law and everything in between, including but not limited to how mediation works within the context of divorce and the dynamics which are at play depending on which part of the divorce process you get involved in, or at which stage of the divorce process you get involved in. This is one of my favorite trainings to present, Divorce 101. Go to thinklegal.co.za, register if you would like to attend. If you are a candidate attorney wanting to attend, please email info@vermeulenlaw.co.za and Jadine will assist you from there. As always, thank you so much to our supporters, Vermeulen Attorneys, Malan Vermeulen Incorporated, Lawbox Practice Management Software, for being very patient with me and providing me with the infrastructure to present these trainings. Right. Get into the family law roundup for February 2026. Our first judgment comes all the way from KwaZulu-Natal. It is the matter of MRS versus BS and others in the Durban High Court. The judge was Mossop J, and although the term BS might be in the citation, the court was having none of said BS in this instance. The matter revolves around a rescission of judgment for a divorce order which was sought on an unopposed basis. Now, what had happened here is that the applicant brought an urgent application to rescind a divorce order which was granted in the unopposed divorce court as an unopposed divorce. The divorce action was far from unopposed. In fact, it had been defended. A plea had been delivered, and thereafter the matter was enrolled and moved on the unopposed motion roll in the Durban High Court. The court had to determine in the rescission application whether the order was erroneously granted in terms of Uniform Rule 42(1)A, and whether Simultaneously with the rescission being granted, ancillary relief could be granted for the preservation of certain assets pending the finalization of the divorce action. The court obviously deeply scrutinized the conduct of the first respondent and their attorney in deliberating on the matter, or deciding on the matter, at least adjudicating, I suppose, is the best word, on a Friday after a long week. What does this judgment look at? If you are involved in matters dealing with Uniform Rule 42(1)A, judgments erroneously granted. If you are dealing with matters where the candor of legal practitioners is at play, de bonus propria costs, and so forth, this is a good judgment to read. It is a 14-page judgment, and as always, as we can see in most of the judgments by Mossop J, the court taking a very definitive stance in this matter. Unsurprisingly, the divorce order was rescinded. Funds were ordered to be preserved and to be paid into trust. Obviously, it follows that the matter then proceeded as a contested or a defended divorce action. The attorney for the first respondent was ordered to pay the costs de bonus propria on an attorney and client scale, and they were referred to the Legal Practice Council. Paragraph 25B is our notable quote, the court making a strong finding, name of legal practitioner redacted from our side, just in the interests of respecting their identity. There is no other way to state it than this was an act of deception on the part of attorney. She deceived the registrar into giving a date on the unopposed roll, and then the acting judge was further deceived when the divorce was presented to her as an unopposed divorce. Paragraph 29, the court goes on to say the legal profession is regarded as a noble profession because it requires those who are permitted to practice it to act with integrity, to fearlessly pursue justice, and to exhibit high ethical and moral standards in order to advance the administration of justice. This was MRS versus BS and others in the KwaZulu-Natal Durban High Court, and the judgment delivered, or the matter finalized on 4 February 2026 before Mossop J. A cautionary tale, folks, for attorneys. There are no shortcuts when it comes to litigation. Next up, we travel all the way to the North Gauteng High Court, to the Court of Nyati J in the matter of JJG versus CG, and our citation ZAGP PHC 80, and the matter handed down on 10 February 2026. The Judge Nyati J, summary page 2, bundle page 15, for those of you wanting to follow along. The matter follows a long line of cases dealing with Uniform Rule 33(4), which we know by now is separation of issues in divorce matters. And the tendency, obviously, that we've been noticing of late is that it is becoming more and more difficult to get a separation in divorce matters. The courts are reticent to grant separations in divorce matters. This is no different. It doesn't deviate from what we could say the shall we say the tendency is, or the zeitgeist is at the moment. However, it is useful to go through the merits of the matter and just briefly discuss it so you know what happened in this case. Applicant sought a 33(4) separation and requested that the decree of divorce and PRR be dealt with first up front, and then later on accrual and spousal maintenance be dealt with under Rule 33.4. So give me the divorce now, deal with parental responsibilities and rights in respect to the children now, and later on in the fullness of time, we will deal with the accrual and with spousal maintenance. Now, the parties had agreed that the marriage had irretrievably broken down and that primary care of the minor child vested with the applicant in line with the Family Advocate report. However, the respondent did not consent to the separation. The respondent opposed the separation, essentially citing financial prejudice. In other words, once the divorce is granted, there is no further reason for the applicant to work with me to get the divorce finalized. The idea of stante matrimonio, there being a duty of support between spouses, obviously goes out the window and so forth. So not unsurprising that the respondent would claim that there would be financial prejudice. There was a pending joinder application for trusts and a corporate entity to be joined to the proceedings. Under the circumstances, it is not surprising that the court declined to give the separation under Rule 33.4. The aspects considered by the court is obviously Uniform Rule 33.4 and the convenience test. What is the convenience test and what does the court consider in applying such test? The notable quote in this judgment, and I won't belabor this judgment much further, is in paragraph 16. And the court states as follows, per Nyati J, separation is contingent on proving that the issues are not inextricably linked and that a separate hearing is, open quote, convenient, close quote, for the court and the parties. In this instance, the convenience test was not met and separation was refused. Next up, we do a hop, skip, and a jump from Pretoria to Johannesburg to the Court of Smit AJ, summary page 3, bundle page 23. The judgment is AS versus BDLM, and the judgment delivered on 5 February 2026. It is a postponement application in a divorce matter, and essentially what had happened here is that the opposed divorce was set down. The defendant, who was represented on the day, unrepresented on the day, sought postponement to obtain legal representation. Obviously, the other party opposed such postponement. The litigation had been prolonged at this stage when it was set down. Folks, you will note that the case number is 2019, so it only takes basic arithmetic that even us lawyers are not scared to do to determine that it was approximately 7 years since the divorce had been instituted. So it had been quite a long road at this stage. And the court was then seized upon to decide whether the matter should be postponed or whether the matter should simply proceed. The postponement was refused. The divorce was granted, joint estate was to be divided with the appointment of a liquidator being ordered. An order regarding care and contact was made, and there was an order made regarding spousal and child maintenance. The costs of suit were to be paid out of the joint estate. Paragraph 19 of the judgment is our notable quote, which says, "It is trite that a court must grant a decree of divorce and does not have a discretion subject to satisfactory arrangements regarding minor children once satisfied that a marriage has irretrievably broken down." So the court per Smit AJ not having it in respect of the postponement, and reasoning at paragraph 19 that once it is satisfied that the marriage has irretrievably broken down, it must grant a decree of divorce. I'd love to hear from our attendees in the chat today whether they agree with this reasoning or not. Obviously, folks, keep it respectful, and let's see what we all think regarding this judgment of AS versus BDLM in the North Gauteng High Court. In most instances, folks, the Rule 43 comes before the divorce. For today's roundup, Rule 43 comes after the divorce. So let's go into Rule 43 land. We have got 1, 2, 3, 4, 5 Rule 43 matters for you today. And let's see. No, actually, my basic arithmetic is up to it this morning. We have 6 Rule 43 matters for you this morning. The first one, we go down to KwaZulu-Natal in Pietermaritzburg. The judge is Besaiden O.J., summary page 6 and bundle page 55. Judgment of NGN versus BTN. It is a Rule 43-6 variation of a Rule 43 order dealing with material change in circumstances and the concept of reduction of maintenance pendente lite. The applicant is the one who sought the reduction of maintenance payable to respondent and 2 minor children. So the respondent was the spouse and then 2 minor children. The original Rule 43 order was granted in default, interestingly, and it required payment of maintenance for the children, respondent, school fees, medical aid, utilities, and the bond. The term, I believe, that's in vogue now, meds and eds. Had a nice nerdy giggle at that this week. The applicant alleged that he had been retrenched and re-employed at a substantially lower salary, constituting a material change in circumstances. Respondent challenged the procedural competence of the application, so there were some technical points argued, and the reduction was obviously opposed. Judgment looks at Uniform Rule 43-6, obviously. It looks at material change in income on the part of a spouse paying, the payer, not the payee. And it looks at the question of adjustment of standard of living upon separation. The reduction was ultimately granted, interestingly, in this matter. Maintenance for the children was reduced to 6,000 Rand per month and respondent 4,000 Rand per month and costs reserved. It was held that a Rule 43-6 application is competent where there has been a material change, which we know the applicant satisfied the court that he was retrenched and then re-employed at a lower salary that was, for purposes of Rule 43-6, considered a change in circumstances. Now, I thought paragraph 12 was an interesting quote, and you can see the influence of the old Rule 43 cases on this quote, I feel, and the court's stating purpose note at paragraph 12, it is indeed so that the applicant must maintain his minor children and his wife, but it must also be considered that the parties have to amend their standard of living as 2 households now have to be maintained. The court erring on the side of, or the court edging towards the side of saying we must be realistic. There are now 2 households and money only goes so far. So very interesting judgment. NGN versus BTN, KwaZulu-Natal High Court, Pietermaritzburg, Besaiden O.J., and the reduction in maintenance pendente lite granted on the basis of retrenchment and re-employment at a lower salary. Next up, folks, let's go to the South Gauteng High Court back in Joburg. And this is, I think, our key judgment for this particular roundup. So if you are listening in the background while doing some work, this is the time to listen up, because I think this is a judgment that would have profound implications for us in practice. The matter is GJT versus SAT and others. I'll give you the full citation: ZAGPJHC 154, the Judge Wanless J, and the summary contained on page 7 and bundle page 61. It is a 48 page judgment, and it is a complex judgment. What it deals with is the appealability and or non-appealability of Rule 43 orders, and this specifically in terms of Section 173 of the Constitution. Now, we know, folks, that Rule 43 orders cannot be taken on appeal, them being interim in nature. We've had a long line of cases dealing with this matter all the way from the Western Cape through Gauteng and so forth. It has been held to date that, and correctly held if one considers the rules, that a Rule 43 order cannot be taken on appeal because it is interim in nature. Unfortunately, what happens from time to time is that an order is granted that is completely unjust and erroneous, and what relief is then available to the aggrieved party in terms of such order? And that is exactly what this judgment deals with: GJT versus SAT and others. The matter revolves around a contribution to costs order of a whopping 2.2 million rand that was made against a party in a divorce proceeding in favor of the other party. And the aggrieved party, obviously the payer, not the payee in this instance, instituted an application in terms of Section 173 of the Constitution to set aside that order as unjust and erroneous. We know that no appeal lies under Section 16(3)(b) of the Superior Courts Act, and no material change in circumstances exists to allow them to invoke Rule 43(6). Now, there were interrelated contempt and stay applications and so forth, but I'm going to zoom in on and focus in on Section 173 of the Constitution. Now, Section 173 of the Constitution empowers the court to regulate its own processes and to protect its own processes. So under the Constitution, our superior courts have certain powers, Section 173 power being one of them. Now, in this instance, the court was mindful of the fact that there is no appeal under Section 16(3)(b) and that there is no change in circumstances under Rule 43(6). So the question was then begged, can a Section 173 of the Constitution mechanism be utilized to amend or vary an order, or in essence set aside as well, apologies for omitting that, to vary, amend or set aside a order made at Rule 43 in the absence of an appeal and in the absence of a variation under Rule 43(6). The judgment looks at Section 173 of the Constitution, obviously the inherent power of the High Court to regulate its processes and develop the common law uniform Rule 43(6), Section 16(3)(b) of the Superior Courts Act, and the exceptional circumstances test, S versus S, Incubator Holdings versus Ellis, and so forth. And essentially, the court had to look at the procedural lacuna under Rule 43, that there is no mechanism in the rules to deal with a patently unjust outcome. Interestingly and very importantly, practitioners dealing with divorce, the application succeeded. The contribution to costs order was set aside. Contempt application dismissed. The stay application was moot because obviously the order was set aside, and the respondent was ordered to pay the costs, and quite what a costs order it was. The court states, paragraph 112 of the judgment, in the present matter, there is no mechanism to deal with an unjust and erroneous Rule 43 order, since there is no right of appeal and no changed circumstances. Arising therefrom, this court is entitled to intervene in terms of Section 173 of the Constitution, acting in the interests of justice. However, folks, the court qualifies this at paragraph 119 of the judgment. And just before we start throwing out babies with bathwater, the circumstances where this can happen are very clear and very much ring-fenced and limited. The court states at paragraph 119, this court finds that applicant has satisfied all the requirements entitling this court to intervene in this matter in terms of Section 173 of the Constitution. In that regard, it is my view that the previous order is unjust and erroneous. Unjust and erroneous. Accordingly, exceptional circumstances exist for this court to intervene in the interests of justice. The question is begged whether this matter will go further. As you can see from the citation, the matter was heard by a single judge of the High Court. I would surmise that further appeal routes might be available to either of the party, either to the full bench or to the Supreme Court of Appeal. And I think certainly because there is a constitutional point that is at play here in terms of Section 173 of the Constitution, it might even go to the Constitutional Court, but that is speculation. For now, I think GJT versus SAT sets an interesting precedent and a much needed, respectfully, mechanism for Rule 43 orders which are patently unjust and erroneous to be addressed. However, it does also open the doors, friends and colleagues, for abuse because of the fact that unjust and erroneous are also terms capable of interpretation. So GJT versus SAT, please do yourselves a favor and read that judgment. It is going to become an interesting point of discussion, and I see it being quoted favorably and unfavorably, most likely going forward. But it's one thing is for certain, it does set a very interesting precedent. Next up, we go to NL versus RNVL, back down in the Western Cape in the court of Tulare J, summary page 8 and bundle page 109. The matter deals with mediation and Rule 43, interestingly. It deals with Rule 41 capital A and the requirement of signature of a joint minute to formally enter into the mediation process. Now, some of you who have attended some of my mediation training will know that I refer to the joint minute under Rule 41 capital A as a litigation side instrument, which essentially signals to the registrar, to the court, to the parties that mediation has been embarked upon. It is an on-the-record document which is delivered to the court, and it fulfills a very important function, which is illustrated by NL versus RNVL. The issue at play here is condemnation for late delivery of a Rule 43 reply based on the assertion that the parties had gone into mediation and that the time periods had been suspended under Rule 41 capital A. However, the parties did not go into mediation proper. The parties agreed to mediation initially, but withdrew before the Rule 41 capital A minute was signed. So there was an agreement between the parties that there would be a mediation. Apologies, disconcerting seeing people over my shoulder here in the background, but I will tough it out. My already 10 years train of thought now having derailed halfway to Bloemfontein, let me compose myself. The parties having agreed informally that they would mediate, later withdrew from mediation and did not take the formal next step of signing the joint minute to enter into the mediation process. The court seized upon, in this instance, to determine whether the dies or the time periods in terms of the rules of court were in fact suspended in the absence of signature and of a joint minute under Rule 41 capital A4. The question was answered in the negative. In the absence of signing a Rule 41 capital A joint minute, there is no mediation process that commences under the uniform rules of court. So the Rule 41 capital A4 joint minute signed between the parties, delivered to the registrar, is the only document that, or is the required and requisite document to suspend the time periods under the uniform rules of court. Without this document, the time periods are alive. Now, this is a notable and important judgment, I think, for lawyers and for mediators engaging in Rule 41 capital A mediations, and please do take note of that. What was interesting in this instance is that the court did not close the doors on the party claiming condemnation in instance of or alleging that there was a suspension of DAs. The application, the Rule 43, was postponed. They were granted leave to file further replying affidavits, and condemnation and wasted costs were reserved for determination by the Rule 43 court that hears it in the fullness of time. The notable quote, paragraph 3 of the judgment, very relevant, lawyers and mediators. The court states unequivocally the signature of the joint minute by both parties, not one of the parties, both parties, suspends the filing of affidavits and notices. Absent the signed joint minute, the suspension is not triggered. In other words, no joint minute, no suspension of time periods. Isn't it wonderful, friends and colleagues, that we are finally getting case law on mediation in civil procedure under Rule 41 capital A? And there are lots of gray areas in terms of the interface of mediation and litigation. And there has, up to very recently, I would say recently, relatively in the last year or two, at least in the civil high courts, not been much by way of case law, but we are now getting some very, very interesting case law emanating from our courts, and it is worth keeping an eye open for those cases, whether you are a mediator, attorney, or related professional. That was NL versus RNVL, Western Cape High Court, Tulare J, on 2 February 2026. Next up, as I massage the life back into my temples, the little headache brewing, let's go on to SJ versus J. We move along briskly despite the things put in our path to trip up my train of thought today. SJ versus MMJ, 2 February 2026, Kaba AJ being the judge, South Gauteng High Court, summary, page 9, bundle page 115. The matter deals with interim maintenance, contribution to costs, referral to the family advocate, and the issue is raised in the instance that there was a material non-disclosure by the applicant. So applicant sought relief for interim maintenance for 2 children, interim spousal maintenance, contribution to legal costs, and defined contact. The respondent opposed, firstly going on to allege material non-disclosure, specifically that he had already paid substantial amounts, and he then brought a Rule 43.6 counter application for increased contact and shared residence. The court looked at various aspects, including but not limited to the aspect of best interests of the minor child, as is always the case in matters involving minor children. The referral of the matter to the family advocate, and a little bit of a reference back to our old Solar case per Satchwell J, as she then was, in the judgment, full and frank disclosure a la Dupree. So there's a big reference in this judgment to Dupree versus Dupree being our locus classicus on non-disclosure, and DCS versus GRS. The court looked at Uniform Rule 43.5 and the evidentiary aspects of arriving at a just and expeditious decision. The Rule 43 relief, the financial relief, was refused. Contact and residence status quo maintained, and the Rule 43 court referred the matter out to the Office of the Family Advocate for an investigation, as the court is well entitled to do, as we are patently aware. The court, having strong words at paragraph 42, referring to what it sets out in paragraph 41 as the material non-disclosure a la Dupree, as we referred to earlier, the court says, "To my mind, the practice is distasteful, unacceptable, and should be censured. Such conduct, whatever the motivation behind it, is dishonorable and should find no place in judicial proceedings." Very strong quote. Please go and read the judgment if you are intending to use it in heads of argument or otherwise. Paragraph 51, the court goes on to say the applicant exaggerated her expenses and understated the support that the respondent was providing to her and the children. This is dishonorable conduct which has no place in judicial proceedings. The repetition of the term dishonorable and no place in judicial proceedings for emphasis. Very interesting judgment, SJJ versus MMJ before Kapa AJ in the South Gauteng High Court. Next up, we go back to the Western Cape High Court. Another interesting judgment from the Western Cape. Holderness J is the judge. The matter is CVS versus SVS. It is a Rule 43.6 application for variation based on a material change in circumstances. The matter deals with full and frank disclosure and self-engineered financial decline. It deals with the trust as an alter ego. It deals with punitive costs on an attorney-client scale. The judgment is 17 pages long, well worth a read if you are dealing with any of these matters within your practice. This was the third Rule 43.6 application brought by an applicant, seeking a drastic variation of existing interim maintenance orders, which were granted 26 January 2023, 15 June 2023. He wanted to set aside all cash maintenance payable to the respondent and their 2 minor children, and to cease payment of rental and household expenses. He alleged a material deterioration in his financial circumstances. The litigation in this instance followed 2 prior 43.6 applications, one of which was dismissed as an abuse of process, and a finding of contempt of court. The court was seized upon to determine whether a material change in circumstances was established and whether full and frank disclosure had been made. The court looks at the strict requirements for Rule 43.6, the strict interpretation of material change in circumstances being the threshold for the court to be seized with jurisdiction or to be clothed with jurisdiction to hear the matter. The onus to prove the material change is obviously on the one alleging, and it is on a balance of probabilities, being a civil matter. The requirement of full and frank disclosure unsurprisingly rears its head in this matter. The court looked at the best interest of the child standard and took a good look at self-engineered change in financial circumstances. The court looked at the trust as an alter ego and disclosure obligations of trusts and companies in these types of proceedings. I'm sure none of you are surprised, considering the lead-in, that the Rule 43.6 application was not successful. The applicant was ordered to pay costs on an attorney and client scale. I will share with you what is held in the judgment in this particular case. On our summaries, for those purchasing the summaries under the outcome, we have a little section of what is held in the judgment. I don't share this on the open platform because that is reserved generally for our attendees who purchase the course pack, but I do generally go into one or two to just share that where I feel that a little bit more exposition is necessary. This is one of those cases. The court held at paragraphs 4 and 6 that Rule 43.6 must be strictly interpreted and that the applicant bears the onus of proving material change of circumstances on a balance of probabilities. An applicant seeking reduction of interim maintenance must make full and frank disclosure of all elements comprising their financial position, paragraphs 5 and 13. A change in circumstances, very importantly, that is strategically engineered or arises from manipulation of financial affairs does not constitute a change in circumstances or a material change in circumstances for Rule 43.6. That's at paragraphs 36 and 43 of the judgment. The court held, the court stating at paragraph 36, the alleged change in circumstances has been strategically engineered by the applicant himself. Nice wording used by the court in this case. Strategically engineered by the applicant himself. Paragraph 50, the court states, over the years, courts have awarded costs on an attorney-client scale to mark their disapproval of fraudulent, dishonest, or mala fide conduct, vexatious conduct, and conduct that amounts to an abuse of process of court. And in this instance, that type of order made against the applicant. So, CVS versus SVS, another notable and interesting judgment in February 2026 on self-engineered changes in circumstances or strategically engineered changes in circumstances in divorce and Rule 43.6 matters. That's CVS versus SVS. Our final Rule 43 judgment for February 2026 is RMG versus DJMG. It is in the North Gauteng High Court, Pretoria, and the judge is Nyati J. Summary page 13 and bundle page 152. It is once again a Rule 43 that looks at abuse of process and the ubere fides as is expounded upon in Dupree, that must be shown by parties in the Rule 43 court. It dealt with pendente lite, maintenance, and a contribution to costs. It was obviously an opposed Rule 43 proceeding. The applicant sought additional cash maintenance over and above respondents' direct maintenance for household and child-related expenses, as well as a contribution towards legal costs. The respondent, who was employed in the land of lochs and whisky in Scotland, already paid substantial fixed expenses for the children and the household. The applicant, retrenched shortly before launching the Rule 43 application, resumed employment days later, but did not formally supplement her papers and alert the court to her re-employment. The court in this backdrop had to determine interim maintenance, contribution to costs, and whether the application did indeed constitute an abuse of process. To this end, the court looked at the principles in Nilsson versus Nilsson. Rule 43 is not an interim meal ticket. The principles were restated ACC versus ALC. The scrutiny of bona fides interim relief should not be weaponized. Finally, importantly, Dupree versus Dupree, the requirement of good faith to the extent uberime fidei, and what a lovely term, uberime fidei, the upper echelons of absolute good faith required in Rule 43 proceedings. The application was dismissed as an abuse of process. Applicant ordered to pay respondents party and party costs, including counsel, taxed at scale B under Rule 67 Cap A. The court saying very succinctly, paragraph 13 of the judgment, Rule 43 is reserved for cases where one party cannot meet basic living needs. This is not such a case. That is RMG versus DMG before Nyati J. Right, we are making very good time on the Family Law Roundup for February 2026. I'd like to circle back and encourage those of you who are inclined and keen to do so to go to thinklegal.co.za. You can register for events, join our WhatsApp groups, purchase resources, and get a link to our YouTube channel where you can view some of our past webinars. I would encourage you to purchase the optional course pack. It's 350 Rand. To do so, it gives you essentially 25 pages of summaries this month and another 264 pages of judgments to keep yourself up to speed on what is happening in family law in South Africa. Further, for those of you who are keen to join me next week for Divorce 101, one of our older and one of my favorite ones to present, 18 and 19 March, 2.5 hours each evening. It's a 5-hour session. And we will be going through the substantive, the procedural, and the ADR aspects of divorce in South Africa. I focused earlier on our concessionary rate for candidate attorneys at 700 Rand, and I want to, in this plug, encourage those of you who deal with divorce and have those pressing questions where, much like the meme, we say, I don't know what this is, and at this point I am too afraid to ask. This training is for you. We will go through divorce in South Africa, the ABCs and all the way to the Zs in terms of how divorce process works, what are the principles at play, when can a divorce not be granted, and so forth. So I do encourage all of you to join me next week, Wednesday and Thursday, for Divorce 101, CPD accredited for 5 CPD points, continued accreditation or renewed accreditation with the South African Association of Mediators. We confirmed that about a week and a half back, our continued accreditation, and we look forward to seeing all of you there. If you are inclined to register the old school way and you are nervous of purchasing tickets online, please email info@vermeulenlaw.co.za. Jadine is standing by to assist you. We are more than happy to issue an invoice, and you can then make payment by EFT, and we will register you accordingly. And that then takes care of the Divorce 101 plug. I wanted to say something else. It's going to strike me 2 hours later, and I'm going to kick myself for forgetting. But nevertheless, time and tide, wait for no man. Let us proceed. Next up, we go into a matter revolving marriages. It is Monyeleote versus Department of Home Affairs, and another, to my utter annoyance, another family law case that did not enjoy the poppy redaction on our platforms where we are able to get hold of them. I've cited them in the form that we found them for purposes of allowing you to find them. Monyeleote versus Department of Home Affairs and another, and I'm pretty sure I've butchered that surname as insult to injury. Van Niekerk AJ being the judge, North Gauteng High Court, summary page 18 and bundle page 179. The matter interestingly deals with registration of a customary marriage and a failure to review under PAJA, which is the Administrative Justice or Administrative Justice Act kind of proceedings. So what happened? The applicant sought an order compelling the Department of Home Affairs to register an alleged customary marriage between himself and the deceased and to issue a marriage certificate in terms of Section 4.4 of the RCMA. The marriage had not been registered prior to the death of the deceased. The applicant relied primarily on a lobola letter and confirmatory affidavits. The court had to determine whether the relief was competent, whether the correct party had been cited, and whether sufficient evidence existed to establish a valid customary marriage. The judgment looks at Section 3 of the RCMA, Section 4.4 and 4.7 of the RCMA, the investigative duty of the registering officer and the court under the RCMA, PAJA, Section 6.2G, 6.3A, and 8.2, review for failure to take a decision and the just and equitable relief available under such sections. The court looked at the separation of powers, Trencon Construction versus IDC, looked at living customary law, MM versus MN, which is one of our very recent customary law marriage cases. Proof of customary marriage and collateral evidence, Manwadu versus Manwadu, and the development of customary law, which is Shilubano versus Nwamitwa. Principles were restated from EMK versus EMB. The application was dismissed. No order was made as to costs. The court found, paragraph 27 and 30, very interestingly, the relief sought amounted to a substitution order based on an alleged failure to take administrative action which should have been pursued by way of a PAJA review under Section 6.2G. So the court erring on the side of caution and saying, look, it was administrative action that should have been taken here. A decision was not taken. You had review at your disposal. The court explaining in explanation of the stance taken, paragraph 29 and 31 being our notable quotes, the RCMA provides the first respondent with an obligation to investigate the validity of the customary marriage in that it stipulates that the registering officer must be satisfied that a valid customary marriage has been entered into. If regard is to be had to the doctrine of separation of power, the court cannot simply ignore the administrative process required by the RCMA to be followed by the first respondent and to proceed to grant an order without being satisfied that exceptional circumstances exist for such interference. Monyeleote versus Department of Home Affairs and another before Van Niekerk in Pretoria. Next up, we go to the full court of the South Gauteng High Court in Johannesburg, the quorum Wright, Stradom, and Senyatsi JJ, the matter of SR versus TPR, which is an appeal matter decided on 3 February 2026. The matter is quite convoluted, as many of these matters are procedurally where we deal with writs issued by the registrar. Now, let's go through the facts. The judgment, worthwhile to read it yourselves, folks. It's only a 10-page judgment, so please do go and read the judgment for the full rundown of what happened. But let's go through it so I can ease you into it. After being divorced in 2018, the parties could not get enough of each other and remained in dispute about alleged arrear maintenance. The ex-wife procured a writ from the registrar in December 2022 to attach her ex-husband's Liberty retirement annuity proceeds. He then applied to set aside the writ, disputing both legal basis and calculations. She opposed and counter-applied for various other maintenance-related amounts, including the release of the funds already paid into her attorney's trust account. So, what was dealt with in this judgment? The issue of registrar-issued writs for maintenance arrears, attachment of retirement annuity proceeds, and a notice to a debtor regarding liquid ascertainable nature of the claim and disputes of fact. Mootness as a dispositive defense. The writ cannot be used again. The relief is no longer live. Counter application and the appropriateness of motion proceedings versus trial where there are disputes of fact. The effect of admissions or tenders if the debtor admits a specific arrears amount, and self-crediting of the attached trust funds, interest on arrears, condonation, and costs. Lots dealt with in a 10-page judgment. The writ was set aside and replaced on mootness. Counter application partially granted, payments plus interest, and the remainder referred to trial. Quite a serious costs order, as I understand it, against the respondent, and I believe that was on scale C, if my memory serves. Yeah, scale C as from 13 April 2024. The court being quite staunch in saying, in our view, the non-payment by Mr. of the sum of approximately 300,000 Rand and his failure to consent to the release of the 550,000 odd is inexcusable. A very strong wording, inexcusable, used by the court in this instance. That was SR versus TPR, Self-Gauteng High Court, Johannesburg, Forum of Rights, Stradom and Senyati, CJJ. We stay on maintenance and we stay on appeals. We have a judgment by Davis AJ pending the judgment, Pangarkar J concurring, TMS versus IN appeal matter, Western Cape High Court in Cape Town, 19 February 2026. Appeal noted out of time against a maintenance order. So under the Maintenance Act, under Section 25(1), the applicant appealed against a maintenance order by the Cape Town Magistrates Court after a Section 10 inquiry. The parties, who were never married, appeared in person at that inquiry. The appellant challenged the maintenance court's assessment of the minor child's reasonable expenses, appellant's income, and resulting pro rata apportionment. A point in limine was raised at the appeal hearing that the appeal was noted late under Regulation 15. The court had to decide whether to entertain the appeal despite such non-compliance. So the court looked at Section 25(1) of the Maintenance Act, Regulation 15 of the Maintenance Act Regulations, Interpretation Act of 1957. Wow. Madge Court Rules, Rule 51, dealing with appeals. Madge Courts Act 32, Section 84, that the appeal court may extend the time period for noting the appeal. And then a fair hearing and ambushing your opponent by an unheralded technical point in the prejudice assessment. Regulation 15 was criticized as a problematic. There was a call for the minister to amend the regulations. Section 15 of the Maintenance Act. Method of determining maintenance was looked at, and so forth. Much more dealt with in this judgment. It is a, incidentally, just for those of you wanting some light bedtime reading, it is a 40-page judgment. So lots to cover in that judgment. In short, the point in limine was dismissed. The time was extended under Section 84. The court was not having it on closing the doors on the appellant solely due to being out of time. The appeal was upheld. The maintenance order was replaced with revised cash, education, and medical obligations. Paragraph 32 of the judgment dealing with written reasons under Rule 51 of the Madge Court Act, or Madge Court Rules, not the Act. The court finding that reasons are an essential part of the appeal process by requiring the noting of an appeal before receipt of reasons from the magistrate. Sub-regulation 15.2 frustrates the meaningful exercise of the appeal right. I mean, it follows. You should have sight of the magistrate's reasoning before having to note your appeal. The reasoning might be perfectly sound, which would dissuade an appeal. We're almost there, folks. One more judgment to go before I release you into the wild and you release me into the wild. So we are KTD versus ZK, Western Cape High Court, Hague Convention matter determined by Lekuleni J. For those of you following along, you can find it in your summaries on page 23 and in your bundle at page 247. The matter deals with international child abduction under the Hague Convention on the civil aspects of international child abduction, the aspect of habitual residence, wrongful retention in this instance, the idea of consent and acquiescence as a defense in a Hague, the grave risk, the Article 13b defense, the return order, travel documents, and urgency. So lots dealt with by Lekuleni J in this judgment. It is a 23-page judgment, sorry, my mathematics are going out the window, 19-page judgment, apologies. So what happened? Urgent application under Article 12 of the Hague Convention for the return of 2 minor children to the UK, also obviously being a signatory to the Hague Convention. The children travelled from the UK to Cape Town in August of 2025. The applicant alleged wrongful retention from January 2026 when the respondent refused to return them to the UK. The respondent disputed temporariness, alleging consent to the youngest child residing permanently in South Africa, and raised Article 13A and 13B defenses. Urgency, as always, also challenged. The court had to decide habitual residence, wrongful retention, and whether a defense was established under the convention. So first off, was there an unlawful removal or retention? That is the first sine qua non of a Hague matter, without which the mechanisms of the convention are not activated. In this instance, the court had to look at, in other words, were the children wrongfully retained? Secondly, was there acquiescence? If there was acquiescence or an agreement that the children were retained, that goes into the unlawfulness of the retaining of the children, and the matter goes out the window in that instance. If that fails, the court then has to go ahead and look at the Article 13b defenses, the grave risk defenses, as we know. Article 12 of the Convention provides for the mandatory return forthwith of the children where the proceedings are brought within a year, where the Convention is activated, and where there is no Article 13 defense. The judgment looks at Articles 3, 1, and 29 of the Convention, and 29 specifically interesting direct approach to the courts without approaching the central authority, or not bringing the application by means of the central authority. So very interesting judgment to have a look at for that. Articles 13A and B were looked at. Article 13A, obviously the aspect of consent or acquiescence. It must be clear and unqualified. Article 13B is our grave risk threshold. The harm must be serious, and that takes us back to the Koch matter, which went all the way through the Constitutional Court. The court restated the principles in Smith versus Smith, Senior Family Advocate Cape Town versus Houtman, Ad hoc Central Authority versus Koch, and then Sonderup versus Tondeli. The court looked at the urgency of Hague Convention matters and then the best interests of the child standard. As we know, folks, the outset or the starting point in Hague matters is that it is accepted that the best interest of the child will be served by final determinations made of and concerning them in the jurisdiction of habitual residence. So it is not a Section 28(2) of the Constitution, Section 7 of the Children's Act type of inquiry. The child must be returned as a starting point unless a justification exists. In this instance, the court ordered the return to the UK of the children forthwith, respondent to hand over travel documents, sheriff authorized to seize passports, and the respondent to pay the costs. The court at paragraph 38, very importantly, and this has been a problem in South Africa for some time, but it seems that these matters are being expedited much more of late. Paragraph 38, the court stating, matters involving the Hague Convention are urgent in nature. They must be addressed urgently in keeping with the objectives of the convention. That was KTD versus ZK, Western Cape, High Court, Cape Town. Interesting Hague matter not involving the central authority. And I think this is worth reading for that reason alone, folks.